Al-Salkini.
Yes, Your Honor. That's the only issue we may run into. Your Honor, we have reached a resolution in this matter. The state has made another offer, which my client is interested in. However, I'm taking into consideration the language barrier here. I'm not sure, but I have to
I have
double
a
check.
translator.
No, I'm saying, he understands that an offer is a BIP class. The thing is, I'm trying to see if the BIP class is offered in Arabic. That may be the only thing.
Hold up, this judge isn't just processing paperwork, they're gatekeeping comprehension. A plea deal's only valid if the defendant understands it, but here's the catch. Courts aren't required to offer programs in every language. Should they be? Or does that open a Pandora's box of delays and costs? Debate below.
It's an online?
Yes, I'm quite sure they can.
Hold on.
Yeah,
It's an online bid class?
yes, sir. I haven't seen one, so I didn't want that to be an issue when it comes to timeliness.
I usually have experience on these courses. Usually they provide an interpreter.
Okay. They'll
Even
provide-
even for the classes.
Okay. Is that something we have to request prior to?
Yes. Yeah.
Okay. Okay.
For each class.
Okay.
I'm sorry to just interrupt. I was just sharing my experience.
Okay. Because most of them I've seen are English or Spanish, but I didn't know if that would be.
Arabic and French too.
Okay.
So how are we going to get that done? I mean, his case is 227 days old. I'm going to give you guys a couple weeks to get it done.
Yes, we can figure it out. I'll figure it out.
And then I'm going to tell him I'm setting his case for trial.
I'll figure it out.
So-
if she gave a possible alternative as far as getting an interpreter in to assist with the course, so I can.
Mr. Al-Salkini, come up.
I didn't know that was out there, an option.
Okay, guys, I'm going to have a translator interpret, so please keep quiet. Okay, Ms. Kuja, thank you for coming. Will you raise your right hand? Do you solemnly swear to interpret word for word what transpires here?
I swear.
Okay, thank you. Mr. Al-Salkini, you are charged with assault of a family member.
مرحبا أستاذ السكين. أنت هنا اليوم بتهمة الاعتداء على أحد أفراد الأسرة.
Your case is old at 227 days.
ملفك قديم هو 267 يوم.
It appears that you have worked out a plea bargain agreement that you wish to accept.
حضرتك اتفقت على إدانة اللي ناقشت إدانة واتفقت عليها. حابب تتفق على هذه الإدانة؟
No.
Yes.
Due to the age of the case, I'm giving you 2 weeks to complete this class.
بما إنه الملف قديم راح أعطي حضرتك أسبوعين من شان تخلص الحصص.
If it is not complete, your case will be set for trial.
إذا ما تم انتهاء أو استكفاء الحصص بأسبوعين فراح أرسل ملفك للمحاكمة.
Okay, so we'll give you whatever date you want, and then we'll see you in 2 weeks.
Yes, sir.
Okay.
Thank you.
All right. Good luck, sir.
Thank you, sir.
Thanks.
I am authorized.
Let's rock and roll.
Judge, was this one THA?
No, I gave her an application.
To the smoking jacket thing, Judge, that I just, no,
You did. It's okay.
smoking.
Okay.
Well, it's too early, man.
Yeah.
Come on up, sir. Is it De Los Santos you said?
Yes. And it was under Santos
Yes, page
on the
19.
docket, but it's.
I see it. Got it. All right, Mr. De Los Santos, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine because of the high blow. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
On March 9th, 2025, at approximately 6:34 a.m., an officer responded to a major accident on the 6100th block of North Fry Road in Harris County, Texas. The officer made contact with the witness, who was traveling south on North Fry Road, and stopped at an intersection of West Little York Road, and he began to drive. When the light turned green, he was struck from behind. He exited his motor vehicle and observed the defendant in the driver's seat. The officer observed rear damage to the witness's motor vehicle. The witness stated the defendant was transported to the hospital. The officer observed heavy front damage to the defendant's motor vehicle, but no closed or open containers in his motor vehicle. The officer made contact with the defendant at Katy Memorial Herman's Hospital. The defendant stated that on March 8th, 2025 at 6 p.m. he was drinking at a friend's house. The defendant stated he drank until 4 a.m. the next morning. He admitted to driving under the influence, resulting in a major accident. The defendant had visible scrapes and injuries on his face, arms, and legs. The officer observed the strong odor of alcohol upon his breath, red bloodshot eyes, and slurred speech. SFSTs were administered. 6 out of 6 were observed on the HGN. The walk and turn and one leg stand could not be conducted due to injuries. IVs, and the defendant had IVs, and the defendant was wearing a neck brace. The nurse checked his vitals and ensured the defendant was in good health to be discharged from the hospital. The defendant was read the DIC and agreed to a breath test. The results were 0.166 and 0.169.
A major accident and a BAC over twice the limit? Case closed, right? Not so fast. No timestamp for the crash? No recorded SFSTs? Defense attorneys live for these gaps. This is why DWI cases get tossed on technicalities, even when everyone knows the guy was wasted.
How long from the time of the accident to the time that he goes to the hospital? Is it immediate?
So I don't believe it states what time the accident occurred and what time he was transported to EMS, or transported to the hospital, but it's before the officers were able to arrive on scene and do an investigation of the accident.
He doesn't write down what time the accident is? Do you have the OR?
Been a lot of that going on lately in DIMS.
I don't understand who's writing these reports.
I don't know, I thought intake was
No,
supposed
I
to
don't get it.
improve on January.
It's important to know how long it takes him to get to the hospital, right? And then I guess he's discharged immediately after he gets to the hospital. I mean, that can't be because he does, how long does it take to get into an emergency room? It takes forever. When I have a family member that goes to the hospital, it takes 12 hours just to get seen.
Yeah.
And then he goes and he blows a 16 after. I mean, I don't know, look, I'll give you a little bit of time. Take a look to see.
And getting, hopefully the office working clear up. We don't have that back yet. Correct.
I just want to know that there's not a disconnect. Like it doesn't take 12 hours to get from here to here because you know how long it takes to get to hospitals and it's ridiculous. So yeah, I'm going to put it on hold for now because we got a
Just
whole.
today or?
No. Later, like I'll give him a couple, like maybe an hour or so. Do you have anywhere else to go?
I have plenty of places to go.
Yeah, I bet. So go do what you need to do. Come back. Let's revisit PC in a little bit, will you? Please?
Absolutely.
Okay. Take a seat from the jury box. Don't leave. And then I think that we need to do a name change because they have it under Santos, but his name is De Los Santos. De Los Santos is the last name, not just Santos. Nathan, and it's De Los Santos.
That's correct. All three separate.
Or a name change. Right. But it starts with De Los Santos. Right. So that's, yeah. We're going to do a name change.
So you have an office support back.
Okay. Are you ready now or do you want some time to look?
Can we have, yeah.
Can I make a suggestion? Based upon the offense report not having any, go ahead and stand here, and the DIMS report not having the information that they're seeking, I think at this time, no probable cause finding is appropriate. However, it's my understanding that Chief Pace, since I trained him, will probably go and figure out all these facts and get it refiled correctly.
I wanted to give you a little bit of time. If,
Contact the officer.
huh?
I'm going to contact the officer.
And we already.
I didn't want to go that far. I wanted to just see what the report has.
And
Because you being able to go contact the officer a little bit just beyond this you know, because it's not fair to them. But what I'm looking for is how long it takes from the accident to get to the hospital, you know, to see, is it him that's driving? Is he intoxicated at the time of driving? Because that's what it calls for, right? That's what we need to know. So if you can just take a look real quick, go do what you need to do, come back maybe like 45 minutes. I just want to know what the timing.
I was just going to suggest we already have a date of 4/14 that they could get this done in the interim and not have to scramble today with 50 other arraignments. That's all I was suggesting.
And
But
Judge,
it's up to the
looking
court.
at the OR, the timeline is not.
It's
the
not in
OR
there.
for that.
They put any time in the OR?
The times that I have is that the witness said that they had been there since 6:30, sorry, I don't know what that is about, but, the only time that I have is that the blood sample was taken at,
Breath, right.
8.
Breath, right.
He didn't write down what time the accident happened? Or what time he gets on the scene? There's gotta be something, you know? Look at the MDTs, there's gotta be a time when
Sorry, I'm looking at the wrong offense report, Judge, I apologize.
it's okay.
I do have based on the accident report, the crash time was 5:50 in the morning. And I'm not seeing, what we don't have your honor is, I think the time.
I'm not concerned about that. I'm concerned what time he gets to the hospital.
Yeah.
Crash occurs at 5 something in the morning.
Okay.
Does
And
he get
he's
to the-
admitted to the emergency room at 7 a.m. So it's roughly about an hour after.
Well, he gets admitted at 7 a.m.
Yes.
Okay, so we're about an hour and a half after the crash. What time does the officer get there? Start interviewing, do you know?
The crash is at 5:50 a.m. The officers transport the defendant in at 6, so 10 minutes later. And
They transport him to the hospispital?
yes,
Okay.
it's admitted in his emergency room at 6.
What time does the officer get there to start the interview?
Not in there.
Mr. Beadle, I just want to know that everything is in close proximity, because if he gets there, he starts interviewing like 12 hours later, I'm gonna have a problem.
And I think the DIMS will probably be supplemented appropriately. I know how much business you have today. I see all the arraignments here sitting in the audience. I think that they will get it done by the 14th of April, which is what I already have the date for. But I leave it to the court's discretion. I'm fairly certain it's not in there. You're doing great, by the way.
I don't see a time. It just needs to follow right with the hospital.
And the blood draws what time?
It's at
Or the breath test, sorry.
Which is weird in and of itself, Judge, because they said he couldn't do the one leg stand or the walk and turn.
Because
But then they took him off to another location to do a breath test. It's just kind of weird.
It doesn't say there.
you don't even have the time of the breath test?
I no.
So it looks like if we're looking at her I would ask that report, she would leave right to review it before considering it.
What do you think?
We have a date for the 14th. I'm sure they'll do it before then. His appearance is waived anyway, so he doesn't have to be here.
Okay, so,
Do you want to put some potential conditions on
No, I
him,
never
assuming? Okay.
so I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. Any prior DWIs? And valid license?
No prior DWIs and his driver's license is valid.
Okay, as long as you have valid liability insurance and a Texas driver license, you may continue to drive. But if you don't have car insurance, do not drive. It is a condition of your bond. Don't consume alcohol, don't use illegal drugs. Do you understand?
Yes, Your Honor.
I will waive your appearance while you're on bond in this court, but you must stay in touch with them. If they tell me they can't get a hold of you because you're ducking and dodging or you pick up a new case, all bets off. I will put you in jail. You
Absolutely.
understand? Okay, I'll have you sign a reset with Victoria. We'll get you with Fleischer for your bond condition, then you're free to go. All right, Mr. Beadle, always a pleasure.
Robert Shelby and the holdover, you wanted to, Bill Stratton had to leave, you wanted to.
You mind? Yeah, please. So I'd like to do PC. I just want to know, because it's a DWI second, there's also an evading. If you could just give me a brief rendition of what happened, please.
Yes, sir.
When he comes out.
Yes, sir.
Morning, Mr. Shelby.
Morning.
So your lawyer was here before I got here, and he had to leave to go to a funeral. So I wasn't able to, at that time, to do conditions, but I want to put bond conditions on you because you now stand charged with a driving while intoxicated second offense. You're also charged with evading arrest in a motor vehicle, which that one is a third-degree felony. You're facing up to a minimum of 2 years, a maximum of 10 years in prison into Texas in the TVCJ. So can you please give us, you have the right to remain silent. Anything you say can or will be used against you, sir.
On April 3rd, 2025 in Harris County, Texas, an officer observed the defendant's vehicle traveling 117 miles an hour using a rear antenna radar. The officer observed the defendant weaved between vehicles in an unsafe manner and a traffic stop was attempted. The defendant passed an available exit with no indication of stopping and ran a red light. After a 20-minute chase, officers stopped the defendant's vehicle using a pit maneuver. The officers moved the scene to a parking lot, and upon contact with the defendant, the officer noticed glossy eyes and bloodshot eyes with an odor of alcoholic beverage. The defendant was identified by his Texas driver's license, and standardized field sobriety tests were conducted. The officers witnessed 4 to 6 clues on the HGN, failed to keep balance on the walk and turn. The defendant refused the one-leg stand. The officer is a drug recognition expert and observed signs of drug intoxication. The IC was read and the defendant refused. A blood warrant was executed and blood was collected.
Can you run his license, please? Seek his license.
Yeah, he doesn't know. So,
at 117 miles an hour, Mr. Shelby, I'm now taking away your privilege to drive. I'm appointing you, Mr. Pruitt, here in the interest of justice now because your lawyer's gone to a funeral. But I'm putting these bond conditions on you now. And I want you to know that I will do everything in my power to protect my community at all costs. Do you understand?
Yes.
You are not allowed to drive.
Yes.
At all. You will be signing an affidavit. This is a promise that you're going to make to me that you're not going to drive. And if I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand?
Yes, sir.
I'm also ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to put a monitor on your ankle so I know that you're not consuming. You will be tested for drugs and alcohol. If I find that you're using, likewise, I will invoke your bond and put you in jail. If you have a problem with drugs or alcohol, now is the time to address it. Because if you don't, and I see that it becomes a problem while you're on bond, I will address it for you, and I promise you're not going to like the way that I do it.
Whoa. Ankle monitor, no driving, and a SCRAM to test his sweat for alcohol? Pretrial conditions this extreme usually only hit repeat offenders. But here's the question, is this protecting the public, or punishing a guy who's still presumed innocent? Sound off.
Do you understand?
Yes, sir.
I am now sending notice to DPS that you're not allowed to drive any vehicle that's not equipped with an ignition interlock on it. Every officer in this state will know that if you're pulled over and you don't have an interlock on whatever car you're driving, they will arrest you and put you in jail. And that is a violation of your bond condition here. Do you understand?
Yes.
You're not allowed to drive any vehicle that doesn't have an ignition interlock on it. As it stands now, I'm taking away your privilege to drive, so you're not allowed to drive. You will get a device on your ankle so that we know that you're not consuming.
Yes, sir.
So he's not required to get the interlock unless you rescind that order for him not to drive?
Correct. You will get a SCRAM device within 3 days. Within 3 days of your release, you will be required to get a SCRAM device. And if you fail to do it, then your bond is going to be revoked. As it stands now, you haven't made bond on the DWI in your felony case. That's why you're still being held now.
That's a SCRAM device.
It's a device that goes on your ankle so that we detect through perspiration whether you are consuming.
Drugs.
All right. I just wanted to bring you out to give you notice of the condition that we're placing forth on you now. All right? Okay. All right. So we need him to sign this and then sign with Fleischer and then. All right. Thank you so much, Carl. I appreciate it. You are Alejandro Castillo.
Castillo? Yes.
Mr. Castillo, you're charged with failure to stop and give information. essentially leaving the scene of an accident without exchanging information. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 6th, 2025, at 9 a.m. Officers were dispatched to a crash at a location in Texas. Upon arrival, the officer met the complainant. The complainant stated that she was sitting at a red light and she was struck by the defendant, and then the defendant left the scene. The complainant was able to get the vehicle's license plate. The complainant followed the defendant through a residential neighborhood where the defendant lost control of the vehicle and crashed into a house about a mile from the original crash. The complainant estimated damage to be around $2,500. It is not copyrighted.
That's what I was gonna ask you. Okay. Mr. Castillo, I'm going to find that there's sufficient probable cause to go forward with the case. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you in the jail because they sweep it every single day, every couple hours. If they find you in there, they will place an immigration detainer on you. And you will be stuck like Chuck in there until this case is over with. And then you will be shipped off to immigration where you will sit. It takes 9 months just to get a 911 tape here. So you will sit for that time, then shipped off to immigration. I don't know what your status is, but if you're not here with permission, you better live with a halo over your head and not violate any conditions that I put on you now. I'm ordering you not to drive. You do not have a Texas driver license. You do not have liability insurance. You are not to drive. I don't care what is going on in your life. I don't care that you need groceries. I don't care that a baby needs to go to the hospital. If you don't have a Texas driver license and liability insurance and approval from us, you are not allowed to drive. If I find that you break this condition, your bond goes bye-bye. You have the ability to hire a lawyer.
¿Usted puede ocupar su propio abogado, sí o no? No. No.
I can have you fill out an application and I will take a look to see whether you qualify for an appointed lawyer. I need to know everything about you. We are filing conditions that you're not to drive. Do not leave until you sign our bond conditions. Deputy Miranda is now going to give you an application for an appointed lawyer. I will have you sign a receipt with Victoria, and then we'll have you take a seat in the jury box, sir.
Was that financial affidavit?
Yeah. Good morning, Mr. Williams. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Thank you, Judge. On April 7, 2025, in Harris County, Texas, officers were dispatched to disturbance. Officers made contact with the defendant who had blood on his face near his beard and lips and denied that anything was happening. The officers then met with the complaining witness who had a large wound on the bridge of her nose and was still bleeding. Officers also observed blood on the hood of the car. The complaining witness said that the defendant is her boyfriend who had come home and started asking her, "Where is the other guy at?" And then proceeded to punch the complaining witness in the face, causing bleeding. That's it. Yes, Your Honor.
Okay. All right, sir, I'm going to find that there's sufficient probable cause to go forward with your case. There's a protective order that has been issued in this case. Get to know it. If you do something to violate the protective order, the state can and probably will file a violation of protective order. It's one of the worst cases you can pick up. At this point, do we know whether she wants to have contact with him or not?
You just have one moment, Your Honor. There is a rip call.
I don't know if she wants to have contact with you or not. Until we know whether she does, I want to honor her wishes. If she doesn't want to have contact with you, I'm going to order you not to have contact with her. If she does, then we can modify the conditions. I just don't know at this point.
Your Honor, may I say, I spoke with her, as a matter of fact, yesterday. She reached out to me because she wanted to do an affidavit of non-prosecution. And she wanted this case to be dismissed, and she did want to have contact. Of course, I advised my client that there's a protective order in place, so regardless of what she wants, unless the judge gives permission, he couldn't. But from my understanding.
The state can confirm that, Your Honor. She
You can confirm?
wants contacts.
Okay, so I am going to order you at this point not to have any threatening or harassing contact with her. You need to understand that what is threatening or harassing doesn't matter what you think. I don't care what you think. It's what she perceives. So if you go like this to her, that is most certainly threatening, harassing, and it can land you right back in jail. There's a lot of vindictive people in this life, and I don't know what kind of relationship you have with her. But if it's something that you're constantly butting heads, I would be very careful because she calls and makes the slightest, you're the one that's going to end up back in there. Do you understand? All right. So what we'll have you do?
That's a different thing. I have different.
Oh, this is not that. Okay. So I'll modify the bond condition. What I'm going to do is I'm going to take off the residential restriction. However, everything in this order still applies, and it's stuff that you shouldn't do anyways. So make sure you read it and know what it is. You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with her. If she tells you that she can't get a hold of you because you're playing games, you pick up a new case or you become a danger to my community, it's not going to go well for you. Do you understand? Good. I hope so. All right. So we'll have you sign a reset. Don't leave until you sign our bond conditions, and after that, you'll be free to go. Thank you.
May I
Yes,
be
ma'am.
excused?